This video has been published solely for educational purposes. Our topic for today is types of contract. Following are the types of the contract. 1. On the basis of enforceability contract. A. Valid contract. B. Void contract. C. Voidable contract. D. Unenforceable contract. E. Illegal contract. 2. On the basis of formation contract. A. Express contract. B. Implied contract. C. Quasi contract. 3. On the basis of existing duty under a contract. A. Unilateral contract. B. Bilateral contract. 4. On the basis of performance of contract. A. Executed contract. B. Executory contract. 5. On the basis of future contingency of contract. A. Simple contract. B. Contingent contract. Types of contract in detail. Following are the types of the contract. 1. On the basis of enforceability contracts. A. Valid contract. All contracts having the entire elements of contract are known as valid contract in the eye of law. B. Void contract. A contract that is originally valid and binding on the parties may become void if it ceases to be enforceable under certain circumstances. In other words, a contract might start out as legally effective, but if it later meets specific criteria that render it unenforceable, it becomes void. This means that although the contract was valid when entered into, it is no longer enforceable by law due to specific grounds or conditions. C. Voidable contract. Voidable contract are those whose validity depends upon the option of the parties. The contract becomes void from the date of such action taken. It is made without free consent. D. Unenforceable contract. Some contracts are valid but cannot be enforced by law due to technical defects. These contracts are known as unenforceable contracts. An unenforceable contract is one that, despite being valid and having all the essential elements of a contract, cannot be enforced in a court of law because of specific technical issues or procedural problems. E. Illegal contract. An illegal contract is one which violates some rule of basic public policy or is criminal in nature or which is immoral. 2. On the basis of formation contract. Following are the types. A. Express contract. An express contract is one in which the terms are explicitly agreed upon, either through written or spoken words, at the time of the contract's formation. B. Implied contract. It is one that is inferred from the acts or conducts of the parties, or course of dealings between them. It is a result of their particular acts or conducts, thereby law treats them as contracting parties. C. Quasi Contract. A quasi-contract is a legal concept where a court imposes an obligation on a person to pay for a benefit they received from another party, even though no formal contract exists between them. This obligation is imposed by law to prevent unjust enrichment and to ensure fairness. Quasi-contracts are not true contracts, as they do not arise from mutual agreement or consent, but rather from the need to address situations where one party would otherwise be unfairly enriched at the expense of another. 3. On the basis of existing duty under a contract. Following are the types. A. Unilateral contract. A unilateral contract is a type of contract where only one party makes a promise or undertakes an obligation. In this contract, the obligation of the single party is to perform a specific act or fulfill a promise only when the other party performs a specific condition or action. The contract becomes enforceable only when the other party fulfills their part of the agreement. B. Bilateral Contract. A bilateral contract is a type of contract in which both parties make mutual promises to each other. Each party's obligation is to perform their promise, and these promises are made at the time of the contract's formation. In other words, both parties are bound to perform their respective obligations under the contract from the moment it is created. 4. On the basis of performance of contract. A. Executed contract. If both the parties after the contract fulfill their promise, it becomes an executed contract. B. Executory Contract. If both of the parties are under obligation to perform their duties under the contract, it is known as Executory Contract. 5. On the basis of Future Contingency of Contract. A. Simple Contract. In a simple contract, the promisor binds themselves to perform regardless of any conditions. There is a continuous obligation to perform the contract. B. Contingent Contract. A contingent contract is one where the performance depends on the occurrence or non-occurrence of a future uncertain event that is collateral to the contract. If you have any questions or need further clarification, feel free to leave a comment. Also, if you enjoyed or found this video helpful, don't forget to like, subscribe and share it with others who might benefit.